Setting up a new business can be quite exciting, but there are also many challenges. In-depth market research and planning can minimize the risks. Foreign nationals setting up a new business in the U.S. face another challenge. Which visa did they use to be able to enter the U.S. to operate the business once it has been established? Generally, L1 visas are used to set up a new entity in the U.S. when it is a subsidiary, parent, branch, or affiliate of an overseas company. However, foreign nationals from countries with certain treaties with the U.S. have the choice of using the E1, E2, or L1 visa for establishing a new company here. Let's first look at the situations under which each of these visa options can be used for setting up a new company in the U.S. E1 visa. The E1 visa for treaty traders allows nationals of an E1 treaty nation to enter the U.S. and carry out substantial trade. Trade means the international exchange of goods, services, and technology. The item of trade and title for that item must pass from one party to the other in exchange for consideration. The international trade between your home country and the U.S. must be substantial, in the sense that there is a sizable and continuing volume of trade. More than 50% of the international trade involved must be between the U.S. and your home country. To qualify for E1 status, you must show that you have been engaged in the trade for at least 1 year. Number 2, E2 status. The E2 treaty investor visa allows foreign entrepreneurs from E2 treaty nations to enter into the U.S. for the purpose of directing and developing the operations of an enterprise in which they have invested or are in the process of investing a substantial amount of capital. Investment activities include the establishment of or the purchase of a new business. The investment must be significantly proportional to the total investment. That is, usually more than half the total value of the enterprise, or, if a new business, an amount normally considered necessary to establish the business. Number 3, the L1 visa. The L1 intracompany transfer visa allows foreign nationals to enter the U.S. to open a new office in the U.S. of a foreign corporation, provided that premises for the U.S. office have been secured and money has been invested in or set aside for operation of the business. To qualify for an L1 intracompany transfer visa, the applicant must be an executive, a manager, or an employee with specialized knowledge of the company's business and its products and services. And the employee must have worked for the company overseas for 1 year in the 3 years before applying for the L1 visa. Further, a qualifying relationship, such as the parent subsidiary, branch, or affiliate, must exist between the foreign and the U.S. business entities. Factors governing the choice of appropriate visa. Let's look at what we need to check out. Following are some of the basic issues that determine the choice of the most suitable visa category to set up a new company in the U.S. Number 1, let's look at the country of nationality. E1 or E2 visas can only be used if a treaty of commerce and navigation or a bilateral investment treaty exists between the U.S. and the country of nationality of the foreign company or the investor. If the foreign national does not belong to a treaty company, the choice is generally limited to the L1 visa. All right, let's take a look at a couple of cases. Franklin, a national of the UK, a country that the U.S. has long had a treaty of commerce, navigation, and friendship with, has been in the construction business with his father for several years. He has been watching the building boom take off in the U.S. and thinks that now would be a good time to get into business there. His father agrees, and they start looking at the options. Atlanta, Georgia seems to be doing well, so Franklin takes a trip to check it out. His report back to his father is encouraging, so they begin working on setting up a company in the U.S. It is decided that Franklin will come to the U.S. to get the company up and running, and then direct the operations of the company. What visa options does Franklin have? Let's look at a second choice. Vijay owns a very successful hotel in Hyderabad, India. He wants to open a long-term residence hotel in California, catering to Indian nationals on short-term assignments in the U.S. He thinks he can capitalize on the cultural aspect and do a very good business. Vijay thinks he will have to invest about $400,000 in the U.S. to get the hotel started. What options are available to Vijay? We'll come back to both Vijay and Franklin at the end of this article and see what they've decided. Number 2, the nature of the business. An E-1 visa can be used by foreign entities not having a substantial investment in the U.S., but having a substantial trade with the U.S. The substantiality of the trade is determined by the volume of the trade, the number of transactions, and the frequency of the recurrence of these transactions. The E-2 visa can be used to set up an entity in the U.S. if the investment involved is, quote, substantial. The L-1 visa does not have the requirement of a substantial investment in the U.S. It can be used for any venture by international companies to set up a branch, subsidiary, or affiliate company in the U.S. However, it must have a foreign branch. Number 3, employment with a foreign entity. To qualify for an L-1 intracompany transfer visa, the applicant must be an executive, a manager, or that specialized knowledge employee who has been an employee of the foreign company for at least one continuous year within the last 3 years. There is no such requirement for the E-1 or E-2 visas. A treaty national does not have to have worked for an affiliated company overseas. And by the same token, a foreign national with no foreign employer, but who is intending to make an investment or set up a business entity in the U.S. will still qualify for an E-2 visa. This latter individual does not have much of a choice other than the E-visa, if the rest of the conditions are satisfied. Number 4, qualifying relationship. The L-1 visa can be used to transfer an employee of a foreign entity to set up, manage, or work for a related organization in the U.S. The qualifying relationship may be in the form of a parent subsidiary, branch, or affiliate company. For using E-1 or E-2 visas, the company or the individual engaging in trade or investment in the U.S. must have the same nationality as the treaty country. 5, processing authority. E-visa applications are generally filed with the embassy or the consulate in the home country of the applicant. Once the consulate registers the trading or investing enterprise for e-visa purposes, the treaty national may apply for a visa to enter the U.S. On the other hand, getting an L-1 visa is a two-step process. A petition is first filed with the appropriate service center of the U.S. Citizenship and Immigration Services, the USCIS. Once the petition is approved, the applicant can then apply for a visa at the consulate abroad. An applicant who changes to E status in the U.S. by filing a petition with USCIS will still have to repeat the entire application process at the consulate the first time he departs the U.S. An applicant changing to L-1 in the U.S. needs only to obtain an L-1 visa stamp in his passport to re-enter after he departs the U.S. Number 6, processing times. Even though e-visa petitions are processed directly at the embassy or consulate, the adjudication is complex and time-consuming and may take several weeks, depending on the consulate. Generally, it takes 2 to 3 months for most consulates to adjudicate an e-visa application, with practically no provision for expediting the process. An L-1 visa petition generally will take several weeks to process at a USCIS service center. However, the processing time can be reduced to 2 weeks by utilizing the premium processing service. Number 7, period of initial employment. E-visas may be granted initially for a period of 2 years, whereas an L-1 visa for a new company is initially granted for a period of 1 year. Thus, after the expiry of the first year on L-1 status, the applicant has to show that the new company in the U.S. has been doing business during the past year and continues to require the services of the applicant as a manager, executive, or employee with specialized knowledge. Companies that anticipate a slower start to get established in the U.S. may use an e-visa option that gives them that 2-year initial period to set up their operations. Number 8, limit on employment. An e-visa can be extended indefinitely for up to 2 years at a time, provided that the stay of the applicant remains temporary. An applicant in L-1 status, on the other hand, cannot extend his or her L-1 stay beyond a period of 5 years for specialized knowledge employees or 7 years for managers or executives. Once the employee has spent 1 full year outside the U.S. after reaching the maximum, they can start their time in L-1 status again. 9, intention of obtaining a green card. The L1 may be the best route in cases where the intention of the applicant is to ultimately apply for a green card during his or her stay in the U.S. An L1 visa holder may pursue permanent residency and still maintain L1 status. They can apply for an extension of their L1 stay. This may not be possible for the E1 or the E2 non-immigrants. E-visas, though they can be extended for an indefinite period of time, still require the applicant to maintain non-immigrant intent. Starting the permanent residency process may affect the applicant's ability to maintain or extend E1 or E2 status. However, the USCIS and consular officers generally accept the statement of the applicant with respect to his or her non-immigrant intent. 10. Evidentiary requirements. An e-visa application entails complex evidentiary requirements as the applicant needs to prove the substantiality of trade between the U.S. and the treaty nation, or the substantiality of the investment in the U.S. Further, since E1 visa applicants are generally adjudicated at the consulate, no formal appeal or recourse to administrative or judicial review in the U.S. is available for adverse decisions of the consulate. L1 visa applicants for startup enterprises require evidence related to the business and revenues of the foreign entity, the qualifying relationship between the foreign and the U.S. entity, and a detailed business plan explaining the potential of the new entity and its capability to meet business expenses, including staffing requirements. However, a decision made by the USCIS Service Center can be reconsidered at various stages by the administrative and judicial machinery within the United States. Okay, let's go back to Franklin, and Franklin has two options available to him. He can use either the L1A if the company is established as a branch, parent, subsidiary, or affiliate of the company in the UK. He has worked in management for over 1 year, so he meets the basic requirements. The US and the UK have a qualifying treaty, so an E2 would also be an option. To set up the construction company, they will have to invest a significant amount of capital, and they will be hiring a number of employees once the company starts winning contracts. Franklin and his father decided the E2 is the best option for them. It gives them longer to build the company to the level needed to support an executive. VJ has the option of an L1. This is because the U.S. does not have a qualifying treaty with India. However, he is not concerned because his business plan is solid and he expects to have his residence hotel to the point where we'll need his full-time attention within 1 year. He is now looking for a competent manager to take over operation of the hotel in Hyderabad so he can move to the U.S. Alright, concluding here. Finding your feet in a foreign land can be quite challenging and often difficult. As noted before, nationals or enterprises from treaty countries have an advantage of choosing between E and L visa categories for setting up a new company in the U.S. And when different options are available, it is important to make strategic, well-reasoned selections. Since your new U.S. entity may be a realization of your dreams, it becomes all the more important to entrust the process to or seek the advice of experienced professionals who can guide you through the process. VisaPro offers multiple services across multiple locations and is able to work with you regardless of your physical location. VisaPro gives the right tools to companies expanding their operations into the United States. Our ability to deliver fast, easy, and economical service has helped VisaPro build a well-earned reputation of trust and efficiency within the business immigration community. In case you are deliberating over setting up a new business or in the U.S., or wish to enter the U.S. to invest in or manage or work for an existing business enterprise, please contact us.